Okay, let's unpack this. When we talk about immigration enforcement, I think most people just hear the word deportation. Sounds simple, right?
Yeah, it really does. But the reality, the actual legal machinery that DHS, the Department of Homeland Security uses, it's much more complicated. It's not just one single action.
Right. There are actually two main legal pathways they follow, straight out of the Immigration and Nationality Act, the INA.
Exactly. And knowing the difference between these two paths, that's honestly the key. For you listening, understanding this distinction unlocks how the whole enforcement process works.
Because these classifications, they decide everything, don't they? How quickly someone can be removed, what kind of rights they have.
And critically, whether they even have a shot at getting out of detention on bond. It all hinges on which path they're put on initially.
So today, we're diving deep into that exact difference. We're looking at the, let's call it the express lane, that's expedited removal under INA Section 235B,
The swift administrative process.
versus maybe the courtroom path, standard removal proceedings under INA Section 240, the more formal route.
That's a good way to put it. And our goal here really is to paint a super clear picture of these two tracks. We want to break down, who goes where, what are the criteria.
And crucially, how does that initial label 235 or 240 decide if you're detained right away and whether you ever get to see a judge about getting out?
Exactly. We're tracking who gets that fast track out versus who actually gets their day in court, even if it's just for a bond hearing initially.
Okay, let's start with that express lane then. Expedited removal, or ER. The name itself sounds pretty intense, like it gives officers a lot of power. What's the basic idea behind it?
Well, it's designed exactly for that speed and efficiency, at least from the government's perspective. Basically gives immigration officers, whether they're CBP at the border or ICE inside the country, the power to deport certain people very quickly.
And quickly means bypassing the usual steps.
Often, yes. It frequently happens without a formal hearing in front of an immigration judge and without the person having access to a lawyer paid for by the government. The idea behind it, when it was first set up, was really to streamline things at the border and maybe discourage people trying to enter fraudulently.
That sounds like a huge cutback on procedural rights. So, who exactly falls into this category? Who are these applicable aliens subject to this fast track?
The main group, historically and by statute, are what the law calls applicants for admission.
Applicants for admission, what does that cover?
Think about anyone showing up at a U.S. port of entry. Could be a land border crossing, an international airport, a seaport. If they arrive there and they don't have the right documents, like a valid visa or entry permit.
Or maybe they have documents, but the officer thinks they're fake, or that the person is lying about why they want to enter.
Exactly. Using fraudulent papers or making misrepresentations. For those folks, the law under Section 235 generally says they must be detained while their case is sorted out. They're basically put straight onto this expedited track.
Okay, so give me an example. Someone lands at LAX, they have a tourist visa, but the CBP officer believes they actually plan to stay and work without permission.
Perfect example.
Mm-hmm.
That person is an applicant for admission in that moment. If the officer makes that finding, boom, they can be placed directly into expedited removal.
But you mentioned this is expanded, right? It's not just happening right at the border checkpoint anymore.
That's the really significant shift. Originally, yeah, ER was mostly used right at ports of entry, or maybe very close to the land border, like within 100 miles sometimes.
Now, what's changed?
Now, well, policy changes have pushed its application deep into the interior of the U.S. According to the info we're looking at, there's a specific date mentioned, January 21, 2025, where the policy allows ER to be used against non-citizens caught anywhere in the United States.
Anywhere. That's
Now,
huge. But there must be conditions, right? They can't just apply it to anyone they encounter.
right, there are two crucial criteria for this interior application. This is super important for anyone who might worry about being apprehended away from the border.
Okay, lay them out for us.
First, the person must have entered without inspection, EWI. That means they crossed the border somewhere other than an official checkpoint and weren't admitted or paroled by an officer.
Okay, so they didn't go through the proper channels upon entry. What's the second part?
The second part is the kicker, really. The person cannot show that they've been continuously present in the United States for at least 2 years before they were apprehended.
Wait, 2 years. So if someone entered without inspection 5 years ago, but gets picked up by ICE today, they could still be put into expedited removal if they can't prove those 5 years on the spot.
That's exactly the danger. The burden of proof is entirely on the individual, and they need to show that 2-year continuous presence almost immediately.
How immediately? Like, do they get time to call family or gather documents?
Generally, no. The process is designed to be quick. Immigration officers aren't obligated to give you days or weeks to track down old pay stubs or apartment leases. This is why it feels like such a shockwave procedurally. If you're EWI and you don't have proof of those 2 years readily available,
You're likely heading straight into this ER process with very limited rights.
precisely, that lack of proof pushes you onto this track where, frankly, traditional due process is largely absent.
So having that proof, things like utility bills, bank statements, maybe school records for kids, employment letters, having that stuff organized and maybe even copies handy is critical.
Absolutely critical. It's the first line of defense against getting swept into ER if you're encountered in the interior and you entered without inspection. If you fail that test, the consequences are severe.
What are those consequences, legally speaking? What's the biggest difference compared to the regular process?
Finality. The orders issued under expedited removal,
Mm.
they generally cannot be appealed. You can't take it to the Board of Immigration Appeals, the BIA, or ask a federal court to review the decision in most cases.
So the immigration officer's decision is basically the final word.
Pretty much. The power rests almost entirely with that officer and DHS. Once that order is issued, removal can happen very, very quickly, sometimes within hours or days.
Wow. How does someone even know they're officially in this process? Is there a warning?
That's a huge practical problem. An officer might start asking very specific questions about when and how you entered, how long you've been here. That should be a major red flag. That means they're likely assessing you for ER.
But when does it become official?
You know for sure when the officer gives you a specific form, the Form I-860. It's titled Notice and Order of Expedited Removal.
And the advice we often hear is once you get that I-860, the clock is seriously ticking.
It really is. By the time that paper's in your hand, stopping the process is incredibly difficult. That's why many advocates say you should just assume any encounter could potentially lead to ER if you fit the criteria, and try to be prepared with proof of presence beforehand.
Because that I-860 isn't like a court summons, it's more like the final decision itself.
Essentially, yes. It's based on the officer filling out another form, the I-213, which is their record of the encounter, and making administrative findings that you're inadmissible. The I-860 formalizes those findings into a removal order. It's an administrative action, not a judicial one.
Okay, but there is one major exception, right? A potential off-ramp. You mentioned the asylum checkpoint.
Yes, and this is incredibly important. If someone who is otherwise subject to expedited removal says they're afraid to go back to their home country, or if they express an intention to apply for asylum,
The ER process has to stop.
it pauses. They must be referred for a screening. But here's the catch. They only get taken out of the ER fast track if they pass what's called a credible fear interview with an asylum officer.
So it's not a full asylum hearing, just a preliminary check.
Exactly. It's a screening to see if there's a significant possibility they could establish eligibility for asylum or protection from torture later on. The standard is lower than proving the full asylum claim, but it's still a hurdle.
What happens depending on the outcome of that credible fear interview?
If they get a positive credible fear finding, meaning the asylum officer believes they have a credible fear, that's the key. The expedited removal order gets canceled, it's withdrawn.
And then where do they go?
They switch lanes. They get placed into the formal, standard removal proceedings under INA Section 240. They move from the administrative fast track to the judicial process with an immigration judge.
And if they get a negative finding, if the officer says they don't have a credible fear.
Then the expedited removal order generally stands.
Yeah.
And crucially, the law under Section 235B authorizes mandatory detention while they wait for an immigration judge to quickly review that negative finding.
So they get a quick review by a judge, but they're detained while waiting.
Yes. And if the IJ agrees with the negative finding, the detention continues until they're actually removed from the country. The stakes in that credible fear interview are just enormous.
Okay, that mandatory detention piece under 235B is huge. Let's dig into that because detention really dictates so much of the experience. This is where the INA sections feel like a real maze.
It really is a maze. And yes, the mandatory nature of detention for many people caught in that ER stream under Section 235 is one of its most defining and controversial features.
So what's the basic rule for detention under Section 235?
The general rule, especially for those applicants for admission we talked about, is that detention under INA Section 235B1 is mandatory. It's required by the statute while the removal case is being decided.
And the idea behind that is?
The idea is to ensure that people stopped right at the border, or who are treated legally as if they just arrived, don't just melt into the general population while their case is pending. It's about control and ensuring appearance for removal if ordered.
And the biggest practical impact of this mandatory label under 235B is no bond hearing, right? This is where it differs sharply from the other path we'll talk about.
Absolutely. That's the critical consequence. For individuals detained under the authority of INA Section 235B, especially those considered arriving aliens, there's generally no path to getting a bond hearing in front of an immigration judge.
The judge just doesn't have the power to grant bond in these cases.
Correct. The statute doesn't give the IJ authority to review custody or set bond for people detained specifically under this section. Their hands are tied by the law.
Okay, hold on. If an immigration judge can't grant bond, is there any way for someone detained under 235B to get released?
The only potential path is something called discretionary parole. But this isn't parole like in the criminal context. It's an immigration parole granted purely at the discretion of DHS specifically, the Secretary of Homeland Security, or their delegates.
And the standard for getting this parole is?
It's very high. The law says it should only be granted for urgent humanitarian reasons or significant public benefit, think serious medical emergencies, or maybe someone needed as a witness in a major criminal case. It's rare.
And if DHS says no to parole, can you appeal that decision?
Generally, no. There's typically no judicial review available if DHS denies a request for this kind of discretionary parole. It's almost entirely an executive branch decision.
This seems incredibly strict. But haven't the courts pushed back on this, especially when it involves asylum seekers who pass their credible fear interviews but are still held under this authority? I feel like the Jennings v. Rodriguez case comes up here.
You're right, Rodriguez is absolutely central to this.
Yeah.
The Supreme Court looked directly at this issue. They basically confirmed that the statute, INA Section 235B2, does mandate detention for arriving alien asylum seekers who are referred after passing a credible fear interview.
Wait, so even if they pass the credible fear screening and are now technically in the formal Section 230 proceedings path,
Right.
they're still held under the mandatory detention rules of Section 235B where they started?
Exactly. Because their initial classification was as an arriving alien applying for admission, the Supreme Court said that the mandatory detention authority of Section 235B sticks with them throughout their entire asylum process until there's a final decision. The only way out is that discretionary parole we just talked about.
How did the court justify that? It seems counterintuitive if they've shown a credible fear.
A big part of the reasoning relied on something called Chevron deference. That's a legal principle where courts often defer to how a government agency interprets a law, as long as the interpretation is reasonable and the law itself is a bit ambiguous. The court deferred to the government's reading that the statute required mandatory detention in this situation.
Okay, that distinction, arriving aliens versus others, seems really important then. What about the people caught inside the U.S., the EWIs, who also pass a credible fear interview? Are they treated the same way regarding detention?
Now that's where things got really messy and the legal ground shifted back and forth. It highlights how your rights can differ based purely on how and where you first encountered the system.
So how were EWIs treated historically if they passed credible fear?
For a long time, based on a key Board of Immigration Appeals decision called Matter of XK from 2005, the answer was different. The BIA said that individuals who entered without inspection, EWI, were apprehended inside the U.S. and then passed a credible fear screening were eligible for a bond hearing.
Why? What was the difference?
The reasoning was that their detention, once they were put into formal Section 240 proceedings, should be governed by the General Detention Statute, INA Section 236A, which allows for discretionary release and bond hearings, not the Mandatory Detention Statute, Section 235B, which applies mainly to arriving aliens.
So for a while, EWIs who passed credible fear had a shot at bond, unlike arriving aliens who passed.
That was the situation, yes. It created a significant difference in treatment, but the government didn't like that distinction.
What did they do?
In 2019, the Attorney General issued a decision called Matter of MS, which explicitly overruled Matter of XK. The MS decision basically said that anyone initially placed in expedited removal proceedings, whether they were an arriving alien or an EWI caught inside, should be subject to mandatory detention under Section 235 authority, even after passing credible fear and moving to Section 240 proceedings.
So the government tried to make detention mandatory for everyone coming out of the ER process after passing credible fear.
That was the goal, yes, to eliminate that pathway to a bond hearing for the EWI group. They argued Section 235's detention authority should apply universally in that context.
Okay, that sounds like a major tightening of the rules. But you mentioned ongoing legal battles. What's the actual situation on the ground now for these EWI asylum seekers who pass credible fear?
Right now, the matter of MS ruling is facing significant legal challenges. Federal courts have issued preliminary injunctions, basically, temporary orders blocking its full enforcement.
So what does that mean today?
It means that, currently, because of these court orders, asylum seekers who entered without inspection, EWI, and receive a positive credible fear determination must generally be given a bond hearing before an immigration judge.
So that distinction based on entry method is back, at least for now.
It is, for now. It really shows this constant tug of war, doesn't it? The executive branch pushing for broader mandatory detention authority based on the statute, and the courts stepping in, often citing constitutional due process concerns about locking up asylum seekers who've already shown a credible fear. The rules can literally change depending on the latest court ruling in these ongoing cases.
Okay, let's completely switch gears now. We've covered the express lane, expedited removal. Now let's talk about the other route. The courtroom path, standard removal proceedings under INA Section 240. This sounds more like what people might typically imagine as a legal process.
It's definitely closer to a traditional legal proceeding. Standard removal proceedings under Section 240 are formal adversarial hearings. They actually happen in front of an immigration judge.
And these judges, they're part of the courts.
Sort of. They're part of the Executive Office for Immigration Review, or EOIR, which is actually under the Department of Justice, so technically still the executive branch, but separate from DHS, the prosecutors.
Okay. And the person facing removal isn't just called an alien here, right?
Correct. In these formal Section 240 proceedings, the individual is officially called the respondent, and the government side is represented by an attorney from ICE. It's much more like a courtroom setting.
So who ends up on this path? Who gets the formal Section 240 treatment instead of ER?
Generally, it's non-citizens who are protected from expedited removal for various reasons. A major group is lawful permanent residents, LPRs, or green card holders. They usually have greater legal protections.
Usually. Does that mean an LPR could end up in ER?
It's much less common, but technically possible in very specific situations. For an LPR to be put in removal proceedings at all, the government usually has to prove they're removable by clear and convincing evidence. But if an LPR is returning from a trip abroad, they can sometimes be treated as an applicant for admission.
Under what circumstances?
For instance, if they committed certain crimes while they were outside the U.S., or maybe if they abandoned their residency by staying away too long without permission. In those narrow cases, they might face quicker processing, but typically, LPRs go straight into Section 240 if DHS tries to remove them.
Okay, so LPRs are one group. Who else gets Section 240 proceedings?
The other major group are those individuals we just talked about, the ones who were initially in expedited removal, but then they claimed fear and passed their credible fear interview. They get switched over to Section 240.
So passing credible fear is like getting a ticket transferred from the express lane to the main courtroom track.
That's a perfect analogy, yes.
Now, in expedited removal, the key document was that Form I-860, the notice and order. What's the document that kicks off these formal Section 240 proceedings?
It's called the Notice to Appear, or NTA. This is a much more detailed document. It formally charges the respondent with specific reasons why the government believes they should be removed, either grounds of inadmissibility, if they're considered arriving, or deportability, if they're already inside the U.S.
And this NTA is filed with the immigration court.
Exactly. The NTA is what officially starts the case before an immigration judge. Unlike the I-860, which is the order, the NTA is just the charging document that begins the judicial process.
Okay, so you're in front of a judge now. What are the key rights that a respondent has in Section 240 proceedings? This is where they regain some ground compared to ER, right?
Absolutely. The procedural landscape is much better, although the stakes are obviously still incredibly high. We're talking about potential removal from the country. But the respondent has the right to present their own evidence.
They can call witnesses, submit documents.
Yes. They can also cross-examine any witnesses the government presents. And crucially, they have the right to be represented by a lawyer.
Ah, but there's a catch with the lawyer, isn't there?
There is. It's a right to have a lawyer, but at no expense to the government. They have to find and pay for their own lawyer, or find someone willing to represent them pro bono, for free. That's a major hurdle for many people.
What about appeals? If the immigration judge rules against them, is that the end?
No, unlike ER, there's an appeal process. The respondent can appeal the IJ's decision to the Board of Immigration Appeals, BIA. And if the BIA rules against them, they can often seek review of the BIA's decision in a federal circuit court of appeals. So there are layers of review possible.
That sounds like it could take a long time. Is that good or bad for the respondent?
It can be both. More time means more chance to build a case, find evidence, maybe see if laws or country conditions change, but the immigration court system is notoriously backlogged. Non-detained cases can drag on for years.
What about detained cases in Section 240? Do they move faster?
Oh yes. Detained cases are put on a fast track. EOIR, the court agency, often has internal goals to try and complete detained cases much more quickly, sometimes aiming for completion within 60 days of the NTA being filed, especially if there's no immediate relief apparent.
60 days. That still sounds incredibly fast. To find a lawyer, gather evidence from potentially another country for an asylum claim, all while you're locked up.
It puts enormous pressure on detained respondents and their potential attorneys. That expedited timeline for detained cases is a major challenge within the Section 240 system itself.
Okay, let's talk detention again. If someone is in these formal Section 240 proceedings, what's the main law that governs whether they're detained or not?
The default detention authority for people in Section 240 proceedings falls under INA Section 236A.
Section 236A, and what kind of detention is that? Mandatory.
No, this is the key difference. Section 236A authorizes discretionary detention. DHS may detain someone under this section, but it's not required by law in the same way as 235B often is.
Discretionary. Okay, that sounds much better. What does discretionary mean in terms of getting released?
It means there are actual pathways to seek release while the case is ongoing. Individuals detained under 236A have two main options.
What's the first one?
First, they or their lawyer can directly ask IC, specifically the Enforcement and Removal Operations, ERO officers, managing their detention to release them. ICE ERO has the discretion to release someone on their own recognizance, meaning just a promise to appear, or they can set an administrative bond amount.
So you can negotiate directly with IC.
You could try, yes. Sometimes that works. But if IC decides not to release them, or if they set a bond amount that's just too high for the person to pay...
Then what? Is there another option?
Yes, and this is the really important one. They have the right to ask for a bond hearing, technically called a custody redetermination hearing, in front of an immigration judge.
So under 236A, the immigration judge does have the power to review the detention and potentially grant bond.
Exactly. That's the fundamental difference from the Section 235B situation for arriving aliens.
Right.
Under 236A, the IJ gets to make an independent decision about whether detention is necessary and what bond amount, if any, is appropriate.
So getting into Section 240 proceedings and being governed by the discretionary detention rules of 236A is like the first major hurdle cleared if someone is seeking release.
It's a huge initial victory, yes.
Yeah.
It opens the door to that crucial bond hearing before the judge.
Okay, but just because someone is in Section 240 proceedings doesn't automatically mean they get that chance at a bond hearing under 236A. There's another layer here.
Oh, so even within the formal courtroom path, there's another potential trapdoor into mandatory detention.
Exactly. Once someone is placed into Section 240 proceedings via that NTA, the very next question is, does their case fall under the discretionary detention of Section 236A, or are they subject to the mandatory detention provisions of INA Section 236C?
Section 236C. Okay, so this is another mandatory detention statute separate from the 235B one for arriving aliens.
Correct. Section 236C specifically targets non-citizens in removal proceedings who have certain types of criminal history.
So this one is triggered by criminal activity. Primarily, yes. Or certain terrorist-related grounds. The idea behind 236C was specifically to prevent the release of non-citizens convicted of particular crimes while their removal cases were pending, which, as we know, can take a long time. Congress wanted to make sure these individuals weren't released back into the community.
That makes sense from a public safety perspective. What kind of crimes actually trigger this mandatory 236C detention? Is it any crime?
No, it's a specific list laid out in the statute. It covers individuals who are considered removable from the U.S. because of these crimes. Some key examples include, first, crimes involving moral turpitude, or CIMTs. These are generally crimes involving dishonesty or inherently base conduct. There's an exception for very minor offenses, the petty offense exception, but otherwise CIMTs can trigger it.
Okay, CIMTs, what else?
Second, most controlled substance offenses. There's a narrow exception for a single instance of simple possession of 30 grams or less of marijuana, but pretty much any other drug offense can trigger 236C.
Drugs. What about guns?
Yes, certain firearms offenses are also on the list.
And I remember you mentioning aggravated felonies before. Is that category relevant here too?
Hugely relevant. Being removable for having committed an aggravated felony is a major trigger for 236C mandatory detention. And it's crucial to remember that aggravated felony in immigration law is a term of art. It's defined much more broadly than what you might think of as a felony in regular criminal law.
How broadly?
It can cover things that might seem relatively minor in the criminal system, like theft offenses or simple assault, depending on the exact conviction and sentence. It also includes very serious crimes like murder or drug trafficking, of course. But the definition is complex and catches a lot of different offenses.
Okay, so having one of these triggering convictions is step one. Is there another condition needed for 236C to apply? You mentioned something about release from custody earlier.
Yes, that's the procedural hook. Section 236C applies to individuals who are removable for these specified grounds when they are released from criminal custody. Specifically, the law says DHS shall take them into custody when the alien is released from that criminal custody.
So ICE is supposed to pick them up right as they walk out of jail or prison for that triggering offense.
That was the original idea, and it created a lot of legal fights. What happens if ICE doesn't pick them up right away? Say someone finishes their sentence for a triggering crime, gets released, lives normally for 5 years, and then ICE apprehends them. Does 236C still apply? Can they still be mandatorily detained years later?
That seems like a key question. What's the answer?
That question went all the way to the Supreme Court in 2019 in a case called Nielsen v. Preep. Before Preep, some courts had ruled that if ICD didn't take custody reasonably promptly upon release, they lost the authority to use 236C mandatory detention, and the person should get a bond hearing under 236A.
Makes sense. If they waited years, maybe the person isn't a flight risk or danger anymore. But what did the Supreme Court say in Preep?
The Supreme Court rejected that prompt custody idea. They ruled that the statute means what it says. If someone is removable for a listed offense and was released from custody for that offense after a certain date in 1998, then Section 236C applies whenever DHS eventually apprehends them.
So the delay doesn't matter. Mandatory detention can still kick in years later based on that past crime and release.
According to Preep, yes. The court focused on the fact of the qualifying crime and the release, not on the timing of ICE's apprehension. This basically closed off that argument and solidified DHS's authority to use 236C even long after the criminal sentence was served.
Wow. So if someone falls under 236C because of a past crime, they're in the same boat as the arriving aliens under 235B in terms of bond hearings.
Pretty much, yes. If you're properly classified under 236C, you are generally not eligible for a bond hearing before an immigration judge. Release becomes extremely difficult.
What are the options then, if any, for someone detained under 236C?
The main way out is to successfully challenge the reason why 236C applies in the first place. For example, arguing that the past crime isn't actually a triggering offense under the complex legal definitions, or maybe getting the underlying criminal conviction vacated, or, as we'll get into, challenging the detention itself if it becomes excessively long.
Okay, so that's a tough mandatory path within Section 240. Let's go back to the better scenario. Discretionary detention under 236A. If someone avoids all those 236C triggers, they get that bond hearing. What happens there? What do they need to show?
Right, so if you're detained but not subject to 236C, you get your day in court for a bond hearing under 236A. In this hearing, the traditional rule is that the burden of proof is on the non-citizen, the respondent.
The burden to prove what?
They need to convince the immigration judge of two things. First, that they are not a danger to the community if released, and second, that they are not a flight risk, meaning they're likely to show up for their future immigration hearings.
Okay, not a danger, not a flight risk. How does the judge figure that out? What kind of evidence do they look at?
They look at the whole picture, really. To assess flight risk, the judge considers things like, does the person have strong ties to the community? Family members who are citizens or LPRs? A stable job history? Have they lived in the U.S. a long time? Do they own property? These things suggest someone is less likely to just disappear.
What about the danger aspect?
For danger, the judge looks primarily at criminal history, even if it wasn't serious enough to trigger 236 at AM. They also look at immigration history. Have they violated immigration laws before? Skipped court dates? Any evidence of gang ties or threats?
Does the strength of their actual immigration case matter? Like if they have a really good shot at winning asylum or getting a green card eventually?
Yes, definitely. That's a huge factor, especially regarding flight risk. If someone has a strong application for relief pending like a solid asylum claim or eligibility for cancellation of removal or a pending family petition, the judge might reason they have a strong incentive to show up for court to win their case. So that weighs in favor of release.
Are there other factors, like personal circumstances?
Yes, humanitarian factors can play a big role in the judge's discretion. Is the person the sole caregiver for children or sick relatives? Do they have serious health issues that would be hard to manage in detention? These can definitely sway a judge toward granting bond or maybe setting a lower bond amount.
Okay, so connecting all these pieces, 235B for arriving aliens, 236C for certain criminal grounds, and 236A for everyone else in formal proceedings, it really hammers home how critical that initial classification is.
It's everything. Being eligible for discretionary detention under 236A is just worlds apart from being stuck in one of the mandatory categories. That 236A classification is the key that unlocks the possibility of a meaningful, timely bond hearing where a judge actually weighs the individual factors and has the power to grant release.
Whereas under 235B or 236C, you're largely reliant on either DHS's very limited parole discretion or potentially a much longer, harder constitutional fight about the detention itself.
Exactly right. The difference is immense.
Okay, we've established these different detention authorities. Mandatory under 235B and 236C, discretionary under 236A, and the stated goals are ensuring people show up for court and protecting public safety.
Right. Those are the government's justifications for civil immigration detention.
But what happens when detention, especially mandatory detention, isn't just for a few weeks or months? What happens when it drags on for, say, a year, or even longer, while the underlying removal case slowly moves through the system? Doesn't that raise some serious constitutional questions?
Absolutely. This is where we hit the constitutional edge, particularly the due process clause of the Fifth Amendment. The government has broad power over immigration, yes, but that power isn't absolute. The Supreme Court has consistently said that due process protections apply to all persons within the U.S., and that includes non-citizens, even those here without authorization.
And due process, at its core, protects against arbitrary government deprivation of liberty, right?
Exactly. Locking someone up indefinitely, even in the civil context like immigration, without a very strong justification and procedural safeguards, starts to look arbitrary and potentially violates that fundamental right to liberty.
You mentioned the Supreme Court case, Demore v. Kim from 2003, which seemed to approve mandatory detention under 236C for criminal non-citizens. How does that fit in? Didn't that settle the issue?
It upheld the law on its face, meaning the statute itself wasn't automatically unconstitutional. But the court's reasoning in Demore was really heavily based on the idea that this detention would be brief.
How brief?
The court specifically pointed to evidence at the time suggesting the average detention period under 236(6)(e) was only about 47 days for the initial IJ decision, plus maybe a few months if there was an appeal. They explicitly said they weren't deciding whether prolonged mandatory detention would be constitutional.
Ah, so the court basically okayed short-term mandatory detention, but left the door open on what happens if it's not short-term.
Precisely. The entire justification rested on brevity. So if the detention stops being brief, if it stretches on for many months or years, then the rationale from Demore kind of falls apart, and that's where the constitutional challenges come in.
What's the legal basis for challenging prolonged detention? Is there another key case?
The groundwork was really laid in an earlier Supreme Court case, Zadvydas v. Davis from 2001. Zadvydas dealt with detention after a final removal order had already been issued. When the government couldn't actually remove the person, the court said you can't detain someone indefinitely in that situation. Detention must be reasonably related to achieving the purpose of removal.
And courts have applied similar logic to detention before the final order if it becomes prolonged.
Yes, many lower federal courts have reasoned that the same principle applies. If pre-final order detention under a mandatory statute like 236C goes on too long, it starts to look punitive rather than just regulatory, and due process requires more safeguards.
How long is too long? Have the courts set a specific time limit?
It varies a bit by circuit, but a common benchmark that emerged, especially from litigation in the Ninth Circuit involving the Rodriguez case again, is around 6 months.
6 months. So what happens, according to these lower courts, when mandatory detention under 236C hits that 6-month mark?
The Ninth Circuit, for example, held that once 236C detention becomes prolonged, presumptively around 6 months, the legal authority for the detention actually shifts. It stops being governed by the mandatory 236C and effectively converts to being governed by the discretionary authority of 236A.
Wow, that's a big deal. So just because of the passage of time, the detention changes from mandatory to discretionary.
According to that judicial interpretation, yes. And the immediate consequence of that shift is huge.
What's the consequence?
It means the person is now entitled to a bond hearing before an immigration judge, the very hearing they were denied under the mandatory statute.
So prolonged detention basically triggers a right to a bond hearing.
Yes. But the courts often went even further to protect due process in these specific prolonged detention bond hearings. They didn't just grant a hearing, they changed the rules of the hearing.
How so? You mentioned the burden of proof usually being on the non-citizen in a 236A hearing.
Right. But in these prolonged detention hearings, triggered after 6 months, courts like the Ninth Circuit flipped the script. They ruled that the government now bears the burden of proof.
The government has to prove.
The government has to prove by clear and convincing evidence that the person is still a danger to the community or a flight risk, and therefore continued detention is necessary.
Clear and convincing evidence. That sounds like a much higher standard than just preponderance of the evidence.
It is. It's a significantly higher legal standard. It means the government has to present strong, persuasive evidence showing that releasing this person poses a genuine demonstrable risk. It can't just rely on the old conviction or assumptions.
That must put a real burden on ICE attorneys, especially if someone's been locked up for 6 months or more without incident.
It absolutely does. As the government itself sometimes argued in these cases, they might not have much current information about someone beyond their initial record. Proving current dangerousness or flight risk by clear and convincing evidence after a long period of detention is a tough hurdle.
And presumably this framework leads to more people being released on bond in these prolonged detention cases.
Generally, yes.
Hmm.
Shifting the burden and raising the standard significantly increases the chances of release for individuals who have been detained under mandatory authority for extended periods. It acts as a constitutional safety valve.
Okay, besides these court-mandated hearings, are there other ways detention is managed? What about alternatives to detention, or ATDs?
Right, ATDs are another important piece of the puzzle. These are programs ICE uses to supervise people who aren't in physical custody.
What kind of programs?
It can range from things like requiring regular check-ins at an ICE office to telephone monitoring or more intensive supervision like GPS ankle monitors.
And who gets put on ATD? Is it instead of detention or after release?
It could be both. ICE might decide to place someone on ATD directly instead of detaining them under discretionary authority, 236A. Or an immigration judge might order release on bond with the condition that the person enrolls in an ATD program, like wearing an ankle monitor.
So ATD provides a middle ground, some supervision without the actual confinement.
Exactly. It allows ICE to maintain some level of monitoring and accountability, theoretically reducing flight risk without needing to use costly detention beds. It's often used for families, people with health issues, or others deemed lower risk, regardless of whether their detention was initially mandatory or discretionary before release.
It seems like a necessary tool given the constitutional pressures around prolonged detention and just the sheer volume of cases.
It is. It reflects that ongoing tension between the government's enforcement goals and the constitutional limits on depriving people of their liberty during potentially years-long immigration proceedings. #outro.
Okay, so wrapping this up, it seems incredibly clear that the first label slapped on someone, expedited removal under 235B or standard removal under 240, is just fundamentally decisive. It sets the entire course.
It really is the gateway determination. It dictates whether you're facing a swift administrative order with almost no review and mandatory detention, or if you get into the formal court system.
And even if you get into that court system, the battle isn't over. You immediately face that second classification. Are you subject to mandatory detention because of a past crime under 236C? Or do you fall into the more favorable discretionary category under 236A, where you at least get a shot at a bond hearing?
That's the next critical fork in the road. Each classification step dramatically impacts liberty, access to counsel, and the ability to actually fight the removal case.
So when we hear debates about immigration enforcement, it's not just about whether someone should be removed. It's deeply about how. This fight over classification, arriving alien, EWI, criminal non-citizen, it's not just legal jargon.
Not at all. It's the fight for due process. It's the fight for a chance to be heard, the chance to seek release, the chance to gather evidence and find a lawyer. The stakes behind those section numbers 235, 240, 236A, 236C are immense for the individuals caught in the system.
And while the laws try to draw these bright lines, we see the courts constantly pushing back, especially around prolonged detention, invoking constitutional
Right,
limits.
particularly the Due Process Clause,
hmm
trying to ensure that civil detention doesn't become indefinite or arbitrary punishment.
Which leads us to a final thought for you, our listeners, to chew on. Consider the government's power, upheld in cases like Rodriguez, to mandatorily detain people under Section 235B authority throughout their entire asylum process, even after they've passed a credible fear screening.
Remember, the Supreme Court's approval of mandatory detention in Timor rested heavily on the assumption of brevity. So what does it mean constitutionally and maybe even morally to hold someone for months or even years under a mandatory detention statute when their only offense was seeking protection and they've already shown a credible fear?
As the courts continue to grapple with how long is too long for civil detention, especially for vulnerable populations, the fundamental question remains intensely personal for those affected. When your liberty is on the line simply because you sought refuge or are navigating this complex system, how long is too long?